Good evening. Honored to serve as MinnPost Executive Director. We're very grateful to have you with us as we welcome the esteemed journalist Linda Greenhouse for an in-depth conversation on the Supreme Court and the critical and significant role it's playing right now in this moment in history. We want to give a special thanks to our sponsors this evening, the Shavlik Family Foundation, the University of Minnesota Press, and the Minnesota Historical Society with their current online exhibit, Votes for Women. We also want to recognize our executive presenters, Lori and Joel Kramer, who also happen to be our visionary co-founders. Thank you to them and to all of our anniversary patrons for your generous support. We're marking MinnPost's 13th anniversary in a year that, more than most, has underscored just how essential thoughtful public service journalism is, especially at the local level. And before we begin tonight, I want to recognize and thank the talented staff of MinnPost. In the face of many challenges this year, you all have gone above and beyond, giving our readers clarity and understanding of what's going on in our state. Thank you for all the work that you do, day in and day out. I also want to thank our board of directors for your continued leadership and dedication to our mission. Your thoughtful stewardship is the reason we're marking this occasion here tonight. Quite literally, the planning of this celebration is led by the board's events committee, so I want to give a special shout out and thank you to that group as well. And last, but certainly not least, I want to thank the almost 5,500 MinnPost members whose generous support at all levels is crucial to powering our nonprofit newsroom. Your donations are vital to our in-depth reporting and for making that work available to all readers for free, no paywalls whatsoever. Thank you for standing with MinnPost and for believing in the importance of journalism in our civic and cultural life. Now to why we're all gathered around our screens. Our featured guest this evening is Linda Greenhouse. For 30 years, Linda covered the Supreme Court for the New York Times, where she continues to write a bi-weekly column on the court and the law. From 2009 until 2020, she taught full-time at Yale Law School. Linda is the author or editor of numerous books, including a biography of Justice Harry Blackmun. Among many accolades and awards, in 1998, Linda received the Pulitzer Prize for her reporting on the Supreme Court. Moderating the conversation this evening is Andy Putz, who's led MinnPost Newsroom since 2014 as our editor. And with that, I would like to welcome Andy and Linda to the stage.
All right. Hello, everyone. Thank you for joining us tonight. We only have an hour, so I am going to get right to it. I am going to intersperse some of the questions I have with many that actually readers sent in before we, when we announced this event. So I will try and designate which questions are coming from our readers, but I'm just going to put them in because I think we need to move along. Again, we've got only so much time, and I know there's a lot we want to cover. So,
Andy, can I interrupt for
Sure.
a minute just to, acknowledge people, and also just say, although I can't say that I'm a MinnPost reader, I am a devoted reader of two MinnPost lookalikes in my state of Connecticut. The Connecticut Mirror, which is produced in Hartford and covers state politics, and the New Haven Independent, which is in New Haven and is absolutely essential daily read for anybody who cares about what's going on in New Haven. So I'm fully in understanding of and in support of your mission.
Thank you for that. Really appreciate it. So let's get started, I guess. Today is a big day. Obviously, Amy Coney Barrett just finished up the last day of testimony before the Judiciary Committee. First question for you, what did you make of these last 3 days? Was there anything that surprised you about the proceedings, whether it was her answers or how the Republicans and the Democrats on that committee kind of chose to go about holding the hearing and the questions they asked?
Yeah, I can't say anything totally surprised me after having endured the last few confirmation hearings for the court. But what did occur to me, and probably occurred to many other people, this really wasn't so much a confirmation hearing, but a kind of offshoot of the presidential campaign, very much so. So every Democratic senator focused on the Affordable Care Act, Obamacare. Almost each one put up pictures of constituents who, if the Affordable Care Act was overturned, would be in horrible shape and so on. And, I said to a politically connected friend of mine, didn't that get a little repetitious after a while? Didn't it kind of lose its momentum? And he explained to me something I should have intuited, which is that really wasn't the purpose, but rather it was to provide clips to play in the states where incumbent Republican senators are facing reelection. And, since all the Republicans have spent the last 5 or 6 years voting to take down Obamacare, whatever they could, I think 70 such votes since the law was enacted. And so that's what that was about. And from the Republican side, it was, don't worry, Obamacare is terrible. I mean, there was a hilarious thing this morning. It was yesterday. Lindsey Graham starts out, and he goes first because he's the chair of the committee. Obamacare is terrible. Not only is it terrible, but it's so unfair because New York and California are, I don't know what he said, 15% of the population, and they get 22% of the federal money. And that's just so unfair to the rest of us. Well, of course, that's totally meretricious, because the reason New York and California get a larger proportionally than South Carolina, where Lindsey Graham is from, is because their governors accepted the Medicaid expansion, which the South Carolina governor didn't, thereby disabling some hundreds of thousands of people from getting the benefit that the federal government would have bestowed on South Carolina. So, you listen to this rot. And it was kind of torturous, actually. It was a little tough to take after eating.
Was there anything you heard from her at all that was even interesting? I mean, she did as best she could to say almost nothing in terms of obviously the hot button issues that everyone expected her to ask about and probably not get into. But was there anything at all that you could even read as someone who's seen many of these confirmation hearings before, read between the lines, anything you picked up on that you felt was, if not particularly revealing, at least interesting to your ears?
I wish I could say yes, but she was so tightly wound and so programmed that, every confirmation hearing where I think I've seen the limit of how little somebody can say, she exceeded it. I mean, she wouldn't even answer, for instance, I forget now which senators, one of the Democrats said to her, there's an article that's recently been published by, I guess, some right-wing law professor in a right-wing publication, who said that the Medicare law is unconstitutional. And do you think that Medicare is constitutional or not? She wouldn't answer. I mean, for heaven's sakes, it would compromise her. She'd say, yeah, Medicare has been around since 1964 or whenever. And, actually it's perfectly constitutional. It's within the commerce power of Congress, or whatever she was going to say. So, your heart just kind of sinks, and it's a big waste of time. And we really, all we learn of her is her personal demeanor, her incredible ability to stay on task and not give anything away. So that was the name of the game.
There is a kind of a sense, I think, from a lot of people that that kind of display that we've seen for the last 3 days, that kind of raw partisanship, if you will, is sort of the outcome of a process that kicked off with the rejection of Robert Bork in 1987, spearheaded by by Joe Biden himself. Is that accurate? I mean, I think that's kind of, maybe that's conventional wisdom, but, and I know it's simplifying things greatly, but do you see it at least that way in terms of how these hearings have evolved really over the last 30 years? Or would we have gotten there anyway?
I kind of push back against the conventional wisdom on the Bork battle.
Right.
That was a very singular occasion, and people kind of forget the context, although the context is actually remarkably similar to what is going on right now.
Yeah.
The Bork battle occurred in 1987, in the waning years of the two-term Reagan era. The kind of mantle of invincibility had been shed by the Reagan administration. The Iran-Contra scandal, the hearings were going on, a lot of other stuff was going on. The Democrats had retaken the Senate in the 1986 midterms. So the politics are really against the Reagan administration being able to achieve anything they wanted to achieve legislatively in their remaining 2 years. So they couldn't achieve anything legislatively, and they thought they could do it by the court, by putting on the court Robert Bork, who they had not put on the court the year before, when they might have, when the Republicans still had the Senate. They wanted to use the court through his nomination to, as the phrase then was, turn back the clock on a number of progressive initiatives that he had written very critically about. And he had a long paper trail. He was the leading conservative intellectual in the kind of legal silo in that time. And, he had the integrity not to run away from his own record. In fact, he was very emphatic that he still believed everything he'd been writing. I mean, that's to his credit, but it turned out that his beliefs were simply not consonant with the mood of the country. And so here we have a president in his final months in office in this, sad situation with the Ruth Ginsburg vacancy, about to lose the White House, maybe about to lose the Senate, trying to ram this through and to achieve through a judicial appointment a swing seat. Bork was also named for a swing seat. The vacancy left by the retirement of Lewis Powell, who was the kind of Anthony Kennedy of his day. And so there's a big pushback. But unlike in 1987, the White House also controls the Senate. And also unlike 1987, the Republicans then, although a majority of them supported the Bork nomination, they had some renegades. And I think 7 or 8 Republicans voted against the nomination because in those days Republicans were able to think for themselves. And so it was Bork went down to a bipartisan defeat. But I'll just say one more thing, that, that was a very singular occasion, but certainly that didn't begin the Supreme Court confirmation wars. I mean, Nixon lost 2 nominees who the Senate wouldn't confirm. That's why Harry Blackmun used to call himself old number 3, because the first 2 had failed, and he was Nixon's third choice for that vacancy. So, it's just not true that, but for Robert Bork, we'd all be living in a, land of kumbaya when it came to Supreme Court confirmations.
I wanted to talk a little bit about the ACA. You mentioned, obviously, it came up a bunch. Democrats were talking about it a lot during these hearings. There is a case that the court is going to hear on November 10th, I believe. Is it California versus Texas, I think is the name of the case. Can you give us a little bit of just a sense of what actually is the specific question the court, or questions, is the court going to be looking at? And what are the kind of things, again, you'll be interested in hearing in terms of their questions, their response to the arguments there? Because I think obviously a lot of people are very concerned about this.
Yeah, so what's at stake is the ACA unconstitutional? is this the final nail in the coffin that they've been trying to nail down for all these years? That's what the case is about. And the Republicans and the nominee really tried to soft pedal that fact. There was a lot of talk in the hearings about the concept of severability. So what is severability? The part of the statute that the lower court found unconstitutional is the mandate. Now, that was a very foolish and odd holding by the lower court, because Congress had zeroed out the mandate. Nobody has to pay the tax that was originally set up, the individual mandate. It hasn't been in effect for the last couple of years since the big tax law early in the Trump years. So the argument is, because the mandate had been upheld back in 2013 as a tax, as an aspect of Congress's taxing power, when it no longer generates any money, it's not a tax, and so it's unconstitutional. That's not true. It becomes a nullity. That doesn't make it unconstitutional. So the question of severability is, assuming the mandate is unconstitutional, does the entire statute fall? Or can that just be carved out of the law, since it's not in effect anyway and the law's working insofar as it's working? Carve it out and leave everything else in place, the pre-existing conditions, the keep your kid on your insurance until age 26, a whole rest of it. So, the nominee kept saying, well, this is just a case of severability. It has nothing to do with my earlier critiques of the court's earlier decisions that upheld the ACA. And of course, the answer to that is, excuse me, sweetie, if there's found to be no severability, the entire law is wiped off the books. This is really, this is the game that's afoot, and it's very important and very scary.
Do you expect it? I guess, what is your expectation for that case? Do you have any expectation?
Well, as she said today, and that's correct, the presumption in the law, in any law, is there's a presumption for severability. There's a presumption against taking down an entire statute. The question of severability, as she said correctly, is a question of statutory interpretation. The task for a court, when it finds that one aspect of a big complicated law is unconstitutional or invalid for some reason, the task for the court is to say, what would Congress have wanted? Would Congress have wanted the whole law to fall? And obviously, in this case, it didn't, because it zeroed out the mandate, but it didn't zero out anything else. So it's a question of discerning congressional intent. And I think the smart money says that any fair-minded judge or justice would realize that, of course, there's severability. And of course, this entire statute doesn't fall, because the mandate's not even in operation right now. So, I read her to kind of suggest that, but, maybe I'm just projecting my hope onto her, because we're going to have her sitting there by November 10th. And, if the court takes down the whole law under the circumstances that I have just, I think, very fairly described, given the presumption against finding something not severable, given the fact that Congress had it within its power to amend or repeal the statute and chose not to do so, even when it zeroed out the mandate, it would be absolutely shocking act of judicial activism to destroy the entire law at this point.
The other big question, obviously, a lot of people had and have about Amy Coney Barrett, and they tried to get to, obviously, she didn't really answer anything, but obviously about Roe v. Wade, and what her going on to the Supreme Court is going to mean for abortion rights in the United States. Just this summer, there was a case before the court out of Louisiana that was decided 5-4 with Chief Justice John Roberts joining the court's liberal bloc, if you will, to strike down Louisiana law. But you have written about this and talked a lot about what Roberts said in that, and how important that is for people looking to figure out and think about what is going to happen with abortion rights in this country. I wonder if you can talk a little bit about that in terms of explaining kind of at the present moment where the court is on Roe v. Wade, and basically give us a sort of a lay of the land when it comes to that, because I think obviously so many people have a lot of questions about that and what Amy Coney Barrett coming on the court may mean for that.
Yeah, so I mean, we use Roe as kind of a symbol. The actual current law of abortion is a case called Planned Parenthood against Casey from 1992. 19 years after Roe, the court upheld the right to abortion. They modified Roe, and the operative test now is the undue burden test. So a law that presents an undue burden on women's access to their constitutional right to abortion is unconstitutional. So that's the current law, and it came up in the case this summer in a what's known as a TRAP law, TRAP, standing for a targeted regulation of abortion providers. So a regulation that is imposed on abortion providers that's not imposed on providers of other medical services that have a similar, or in most cases, greater risk to the patient. So this is a law that required doctors to have admitting privileges in hospitals within 30 miles of the clinic. That's a very cynical requirement that states passed in the name of preserving women's health. It actually has nothing to do with women's health. It has everything to do with destroying the abortion infrastructure. So the court struck down a Texas law along these lines in 2016 over Chief Justice Roberts' dissent. Justice Kennedy was in the majority. Justice Scalia had died. So the vote there was 5-3. So fast forward to this year, Louisiana had the exact same law, the exact same court, a federal appeals court that had been overturned when it upheld the Texas law, nonetheless went ahead and upheld the Louisiana law, citing a bunch of phony distinctions. And the court really had no choice but to strike down the Louisiana law if the rule of precedent meant anything. So the rule of precedent meant a lot to 4 justices, in opinion by Justice Breyer. It didn't mean quite so much to Chief Justice Roberts, who said, I dissented in 2016. I still think that was wrongly decided. Here's what I think. And he said, we have to strike this law down. Basically, the lower court was in defiance of on-point Supreme Court precedent. He set out a new test that's less protective and kind of suggested that going forward, there are no longer 5 votes for a really robust definition of what makes an undue burden. I could go into more detail, but you probably don't need it at this point. So there's a lot of cases in the pipeline right now. Actually, the Federal Appeals Court, the same old Federal Appeals Court, yesterday struck down a Texas law that, as I understand it, and I haven't had time to fully study this opinion, but it's kind of interesting coincidence that it came down even as the soon-to-be new justice was giving her testimony, would ban abortion, ban a particular method of abortion at 15 weeks of pregnancy, well before viability. So and that's going to be on its way to the Supreme Court. So I think the major question, the major technical legal question going forward, they're not going to overturn Roe in one fell swoop, I don't believe. But the firm line that Roe said and Casey said is viability. That before fetal viability, which is roughly 22, 23, 24 weeks of pregnancy, a woman has an absolute right to terminate the pregnancy. The state can put up obstacles. The state can require, phony counseling, waiting period, jumping through all kinds of hoops. But at the end of the day, the woman has the right to make that choice, viability. These laws that are coming down now, and Lindsey Graham kept referring to one that he has sponsored, I guess, in Congress, would move the date way back into early pregnancy, some as early as 6 weeks of pregnancy, when, of course, many women don't even know they're pregnant. And, of course, it's not easy for women in many states now to even find their way to an abortion provider. So whether the court will adhere to the viability line is, I think, the big next question. And, so are there 5 votes or maybe 6 votes to move that line closer to the date of conception? I think so. Yeah. I think I assume she's definitely there. So that's the way that game is going to play out.
What is the role? We talked about Justice Roberts, Chief Justice Roberts, and his opinion here. But what is his role going to? I mean, what do you imagine for his role going forward? He kind of did play this. I don't know what you would. I don't know how you would characterize it, but he was certainly an interesting figure. Just in the last, in the last term, he joined on some pretty big cases that I think surprised a lot of progressives, frankly, on DACA, on LGBTQ discrimination, the abortion case, like you said, and it does seem like there's been a lot of coverage about his concern about the legitimacy of the court. What do you imagine with the, again, soon to be new Associate Justice coming on board? What role does he play going forward? Does it change from what it's been? Or?
Yeah, I mean, he's got to be one of the most uncomfortable people in America right now, because I think he has tried hard to sort of curb isn't quite the verb I'm looking for, but maybe kind of talk sense to the really activist people to his right, Justice Alito, Justice Thomas, and he won't have that power now, because there'll be 5 justices firmly to his right, 3 to his left, and where does that leave him? So he's been on quite a roller coaster these last 4 years. I mean, when you think of going into the 2016 election, when, of course, everybody assumed that Hillary Clinton was going to win, that the vacancy that President Obama had designated for Merrick Garland was going to be filled by President Hillary Clinton, and obviously be somebody a good deal more liberal than Justice Scalia, whose seat that was. So that would have made Chief Justice Roberts kind of irrelevant in the way that the court was going to be all to his left. Then, these various things happen, and Justice Kennedy retires, and he's what political scientists call the median justice. Right. So, and obviously in any odd numbered group of people, there's going to be a median, and it happened to be these last couple of terms, John Roberts gave him a lot of power. It really was the Roberts Court in function as well as name. And now he's going to go to the kind of irrelevance that the Trump election kind of saved him from in that sense. So how he manages that, I really don't know, because he's got a couple people to his right who are just champing at the bit to kind of pull down modern constitutional law as we know it and setting up all kinds of signals on that. I don't think they necessarily have Justice Kavanaugh or Justice Gorsuch. They may on some of these, and we'll see if they have Justice Barrett. They may well. I don't know.
Yeah, I was going to actually ask, because you did see comments from Thomas and Alito just in the last week, right?
Just this week.
Just this week.
I guess it was last week. Yeah.
And about, and I'm trying to remember, but it essentially had to do with Obergefell. I mean, or it certainly was taken that way. It was. And so that I'm assuming that sort of falls into that camp of sending up signals about things that they're looking to take on.
Absolutely. I mean, they are dead set to kind of privilege religious claims over all other claims in this country, in our law, over claims of discrimination, over everything. So what they said in that separate opinion, which was totally gratuitous, wasn't a case that the court had agreed to decide. They just felt like saying it. Is that the problem with same-sex marriage enabled by the Obergefell decision is that it doesn't take enough account of, the bakers who won't bake, the county clerk who won't sign a marriage license, all these kinds of people who say we can't possibly do our job because our religion, requires us to discriminate. If that's the regime that we're going to be living in, we're going to find out pretty soon. And I think that's disastrous for civil society, frankly.
We are actually going to take on that happy note, we're actually going to take a very quick break here, and we're going to have Kevin Armstrong, a board member of MinnPost, to come in and just talk a little bit about MinnPost and give you guys a bit of a spiel for just a couple minutes. And then Lynn and I will continue our conversation very shortly.
Good evening. Good evening. I'm Kevin Armstrong, and I'm on the MinnPost board. And I was voluntoed. I don't know if you've ever been voluntoed. I was voluntoed by our board chair, Rebecca, to be ready to make some remarks. And I'm excited about doing that. So it's big shoes to fill. But let me just say a few things for starters. It's my honor to represent the MinnPost board of directors this evening. I know that you want to get back to the conversation with Linda. So do I. So I'll make this quick. The past year has proven to show just how essential it is to have good journalism with a shared understanding of values and the health of our democracy and the health of civic life in our state and in our country. And that's especially true for the style of reporting that you get from MinnPost. Local news that takes you deep into the issues and the stories that really matter to our state. They go beyond the what and the when, and it helps you to truly understand the how and the why. Truly, truly important stuff. It's the kind of reporting that takes not only the talented team that we have at MinnPost, but it takes the resources and it takes people like you caring and investing in the important work that MinnPost does. So yes, it took me a few sentences to say this, but I'm here to ask for your help, your continued support, your continued financial support. And I think, we want to be generous because of the great work that MinnPost does. So let me say this. MinnPost is a 501c3. So, it is a nonprofit, it is nonpartisan, and we're just so grateful to have almost 5,500 generous individuals who in the past year alone have donated to support MinnPost's public service journalism. So we thank you on behalf of the board of directors and the terrific staff and our leadership. We thank you for powering the team. So let me just say a couple more things and I'm out of here. This evening marks the 13th year of this work. So this is the 13th anniversary of the vision of Joel and Mrs. Kramer, to put this together, right? But we are at a historic moment, right? This is the most consequential election in your lifetime. I know you've heard that, but their elections do have consequences, and you've heard that from the right and from the left. But this is truly, truly important one. So we need your help. We need your support. So here's what we're going to do. We'll make it easy. We're sending you an email, like right now, while you hear me talking. In your inbox is an email that you can use. The same email address that you use to register for the event is going to come and not use my words in particular, but even nicer words, right? And so it's going to ask for your support. But let me say this. Every story that we publish at MinnPost, every event that we host, every newsletter that we send, all of it is made possible from the donations of people like you. So if you value our work, and that is the work I'm telling you of the staff and the wonderful team at MinnPost, if you value the work, we invite you to be a critical part of the making of the success of MinnPost. So we ask that you donate. So we donate right now at minnpost.com/support. Show your commitment to MinnPost work now and in the future. And any amount will help. It'll make a real difference. And then, by the way, this is the last time I'm going to say this, and I'm going to close here, but because I'm going to start to sound like an infomercial, right? But truly, www.minnpost.com/support, and you can show your support. So thank you for being with us tonight. Thank you for continuing to support this important work in the most important election year in our country's history. And with that, thank you for being with us. And now back to the show with Linda and Andy. Thank you.
All right. Thanks, Kevin. Appreciate it. Okay. Let's get back to it. Linda, I want to get in some questions with the audience, but I'm going to exercise my prerogative and ask you a journalism question, which is one of the things as soon as you agreed to do this, one of the things I wanted to ask you is, how do you cover the Supreme Court when you were covering it as a reporter? It seems like obviously you can make yourself knowledgeable about the law and well-versed about the cases that are coming before, but it seems like such an opaque institution, at least for observers. I don't imagine you're getting a lot of coffees with John Roberts to talk about, what's going on there, or that clerks are particularly talkative. How were you able to cover and write about this sort of, this is still an institution that's run by humans who have obviously influence and a lot of, there's human dynamics there. How did you get to that? How did you do that as someone covering that?
Well, I read everything I could. I guess my general attitude was the court is what it shows itself to be. That is to say, what agenda does it set? It sets the country's legal agenda by choosing, some dozens from thousands of cases that reach it. Most, not all of them, unfortunately, but most opinions that they issue are signed. They take accountability. Every case is there for a reason. Every case reflects some kind of dispute, unease, issue somewhere in the country. So, I didn't spend a lot of time trying to do what was not going to lead to anything, which, knocking on doors and trying to get people to talk to me. They spoke to me through their public work, really. Mm-hmm. And I spent a lot of my time studying the docket and their handling of the docket in a very, very granular way. And you'd be surprised. if you do that day in and day out for a number of years, patterns emerge. Insights might come. I sometimes put stuff in the paper that was simply my piecing things together. And at the end of that term, somebody, a law clerk or a justice or somebody would say, how did you know that? And I say, I just pay attention.
Yeah.
I never had sources. No one ever told me anything they shouldn't have told me. I mean, never in 30 years. You got to believe me. I never had a leak or an inside anything, but I just kept my eyes open. And so that's how it was.
Yeah, I think I saw an interview you did in which you talked about a case that the court was deciding the year that Justice Scalia died, and you had figured out that that it had originally been assigned to Alito, and it was clearly a 5-4 decision, and the reason was because when the decisions actually came out, he didn't have an opinion assigned to him. So therefore, that must have been his case. I just thought that was really fascinating sort of look inside the court from some people. Obviously, most observers would never have known that or sort of gotten that sense of that.
Oh, yeah, but I don't want to claim a lot of credit for that. I mean, that would be like falling off a log to anybody who's living in the Supreme Court press room. That was obvious on the face of it. What I had fun with was finding things like that were not of such high salience and not so obvious. But that's the kind of thing that I mean, that you could learn a lot just by paying attention.
We did get a lot of questions from our readers about election scenarios, and you actually wrote a column a while ago about kind of nightmare scenarios and the things that kind of kept you up at night. And we did get a lot of people wrote in to ask, what if Trump loses and challenges the result? Would it go to the Supreme Court? How would they deal with it? And you wrote this column, I think, before the death of Ruth Bader Ginsburg, before Donald Trump got COVID-19, before some more recent refusals to say he would abide by the peaceful transfer of power should he lose. So I'll ask you the sort of question that you took up before that point. What are the possibilities and the things that keep you up at night when you think about the nexus of the election and the Supreme Court?
Well, of course, I think the main concern, which I'm sure everybody listening shares, is his extraordinary effort to delegitimize the election before it even occurs. Well, of course, it's occurring now, as we know. I voted already myself. So, he's obviously trying to set up a scenario that he thinks is going to allow him to make a plausible claim that the whole election's been a hoax and a fraud, and if he loses, he doesn't have to abide by it. That's an extraordinary claim. If you kind of drill down on it, you could imagine a scenario where he wins the vote that's cast in person on November 3rd. That's not implausible. Apparently, many more Republicans are voting in person this year, or plan to, and many more Democrats are voting by mail-in ballot, which in many states won't be counted until the sun sets on November 3rd. So let's say he wins the vote on November 3rd. That's, of course, not the end of the election by any means this year. Votes keep coming in, and it's what they call a blue shift. He goes from being a winner to being an obvious loser. At which point, one could imagine he would say, I won on election day, and I'm the winner, and the rest of it is just a fraud. And these mail-in ballots are illegitimate, and blah, blah, blah. So, that's kind of a nightmare. And then, of course, we don't go by the popular vote, we go by the Electoral College. So every state submits their slate of electors to the Congress. So let's say in some of these important swing states like Pennsylvania, Wisconsin, Michigan, I believe, there's a Democratic governor and a Republican-controlled legislature. So let's say they each submit a slate of electors. One for Biden, one for Trump. Goes to the House. Now, Congress took account of such a scenario back in the 1870s with the Electoral Count Act of 1877, I believe, which says if there are competing slates of electors presented to the House, that slate, which has been, quote, regularly given, something like that, the use of the word regularly, shall be the official slate of electors from that state. But what does that mean? Who's going to decide that? I mean, there's a whole lot that's not known. In the book I kind of relied on for that column, let me grab it off my shelf. It's right here, I think, is this little book called Will He Go? By a professor from Amherst named Lawrence Douglas. And the main takeaway from this book, which I recommend to people, he points out that, it's nice that we have a constitutional structure and so on, but it doesn't answer these questions. And what has saved us all these years from political disaster are a set of norms. And we've seen this year that every norm anybody can think of has been broken. So that's the problem. Now, people say, well, what's the Supreme Court going to do about that? I think quite plausibly, and I know Professor Douglas thinks this because he and I did a program for the 92nd Street Y in New York, virtually last week. He pointed out, and I think he's right, that this would not be a Bush against Gore situation. So people remember the court, obviously. We all remember the court in 2000, stopped the recount in Florida, thereby effectively calling the election for George Bush over Al Gore. So that was a dispute that was going on in Florida. Who was the winner of Florida's electoral votes, which were the votes that were going to make the difference in the final count. But once the whole mess is within the walls of Congress, and there's a fight over which is the regularly given electoral slate of electors and so on, those are political questions that very plausibly are not within the Supreme Court's jurisdiction. Mm-hmm. Bush against Gore came to the court as a dispute over 14th Amendment equal protection. I think that was a real reach, but nonetheless, it sounded in a conventional jurisdiction for a federal court. Once there's a dispute in the House, that's not within the jurisdiction of the federal courts. And so maybe it's good news, maybe it's bad news, but the Supreme Court, I don't think, is going to get in that mess.
One of the other things that has obviously come up a lot is the notion of court or expanding the court packing, depending on who you're talking to, or expanding the number of justices. What do you make of that discussion? And, what would that actually mean for the dynamics of the Supreme Court, besides just obviously having more members? Democrats have said, Chuck Schumer has said nothing's off the table. Joe Biden has not really said one way or the other what he thinks about it. What do you make of that discussion?
I think it's real. I think it's a serious discussion. I think, from the Democrats' point of view, the Republicans have illegitimately filled 2 seats that they didn't have a right to, and the current one, you can't say they don't have a right to it, but certainly they've broken ancient norms in shoving it in as they're doing, which will give us a majority of the Supreme Court appointed by presidents who did not win the popular vote. So that's a democratic deficit, one might say. And, I think they're very thoughtful people who a couple of years ago wouldn't have thought of pushing to expand the court's membership, who are now taking it very seriously.
The other thing that has come up is the notion of even just some reforms, term limits or age limits. Is that another thing that is actually being, like you said, being taken seriously?
Well, yes, but of course that wouldn't solve the current problem,
right,
from the Democrats' point of view, because all the incumbents have life tenure. Nobody's going to take that away. So we're talking about, changes that really wouldn't have an impact on the court as a whole for a good many years. If it's even possible to impose term limits without a constitutional amendment, there's a debate over that.
Yeah.
And if the decision is that it's got to be a constitutional amendment, that takes many years. I mean, ours is, I think, the hardest constitution in the modern world to amend. That's why there've been so few amendments. And so I think there's a lot to be said in favor of term limits. But as I say, it's not going to solve the immediate problem, and it's not going to happen quickly.
This actually came from a reader, and I thought it was a really interesting question. You wrote a book about Harry Blackmun, Minnesotan, and you detailed in that book his shift, really, while he was on the court. Originally famously part of the Minnesota Twins, very tight with Warren Burger. Then as he stayed on the court, drifted leftward, essentially. Is there any justice, or can you imagine any of the justices now on the court moving in a similar direction, or changing to the degree that someone like Harry Blackmun did?
Not really. There's been some scholarship about this, and Michael Dorff from Cornell Law School looked at Republican-appointed justices since the middle of the 20th century, and Republicans far outnumber Democratic-appointed justices. I forget the exact number, but it's heavily, heavily weighted. Republican presidents have just gotten lucky, and they've had many more vacancies to fill. And looked at that group of Republican-appointed justices who you might say have drifted left, and the group that didn't. And what differentiates these two groups, and what, of course, we're dealing with a small number, so whether this is statistically significant, I don't know. But the ones who drifted left uniformly came from outside the Beltway, had not built their careers in Washington, D.C. They come to the Supreme Court in midlife, kind of shakes you up a little bit. This is quite an adventure. And that, shift of place to live and the whole world that you're now in, can kind of open your mind to new ways of looking at things. Whereas those who didn't change were, you might say, creatures of the Beltway. Mm-hmm. So, John Roberts, when he was promoted from being a judge on the D.C. Circuit to Chief Justice of the United States, his commute increased by about 4 blocks up Constitution Avenue. Sam Alito has never cashed a paycheck that wasn't issued by the federal government. Clarence Thomas, was a Washington bureaucrat. Neil Gorsuch, although he was sitting on a federal appeals court in Colorado, he grew up in D.C. He went to the same high school as John Roberts and practiced law in D.C. before he got his judicial appointment. So, things can change. I mean, obviously, John Roberts is, as we discussed earlier, a very fascinating figure in a very fascinating position. But based on what we've seen in recent history, what we understand, it's not very likely that the current makeup of the court is gonna show an ideological shift.
I'm curious just about when you looked back and still look back after on your career and covering the court, has there been a case or cases that maybe didn't get a lot of attention or were not seen as really high profile at the time that you have come to think as being very important, or at least more important than they were originally thought to be?
Oh yeah, quite a few.
Yeah.
I mean, I think of, with some chagrin about, major things that I now think I miss the significance of. So I guess a major one, although a lot of people missed it at the beginning, was a case called Chevron. Chevron against Natural Resources Defense Council, which became a landmark in administrative law, giving federal agencies much more authority to interpret their own statutory authority without the intervention of a court. It came out of a very interesting political context, which I won't trouble to go into, but that became one of I think the most commonly cited Supreme Court case, like, for decades. And, I think I wrote about it when it came down, but I didn't really grasp the implications of it. The kind of earlier cases in criminal law, in habeas corpus, when the court made a turn to limiting the extent to which federal courts could supervise the quality of criminal justice being meted out by the states. That had been the courts. The federal courts got a lot more authority under the Warren Court, and the Berger Court and then the Rehnquist Court set about to reel that back in, get the federal courts out of the business of second guessing criminal justice on the state level. And I think I missed some of those early straws in the wind of what was really happening. I could go on, but and on the other hand, sometimes things that look really important prove not to be so important. It's in our system, a common law system, that means that every case sets a precedent, and the next round of cases builds on that, and the next round of cases builds on those, and so it's a very dynamic situation. It's no legal dispute is ever, finally over. And that goes for all the cases that we've been talking about in this hour. And that's, really what makes it so fascinating.
Well, we have to wrap up, but I did want to ask you one last question, which is, you write a column, and you obviously pay very close attention to all this, but you're not on the beat, so to speak, as you once were. What was the coolest part about covering the court day in and day out for the Times?
Well, I guess just having a ringside seat at history getting made. I had a seat in the front row in the press section whenever I wanted to use it, and it was a privilege, really, to walk into that building every day. I can't say it was fun every minute. I mean, it obviously had its downsides, but it was. I felt very lucky to have that opportunity. Great.
And we're actually, I'm cutting us off 1 minute early, but that's because I have to give a little bit of an announcement here. So before we end tonight, I just want to reiterate our gratitude to our sponsors, which tonight are the Shavlik Family Foundation, the University of Minnesota Press, and the Minnesota Historical Society, and their current Votes for Women online exhibit. We'd also like to thank, again, our executive presenters, Joel and Lori Kramer, founders of MinnPost, and all of our anniversary patrons. So thank you for your generous support. We also want to thank everyone who donated recently as part of this event. And just to note that we could not do what we do without you. You provide critical support for our reporting. And you can obviously continue to donate anytime at minnpost.com/support. And finally, just thank you to Linda for your time and insight and your work over all these years. We were honored to have you with us, and we really appreciate it. And thank you all for joining us for this conversation. Have a great evening.